Hello everyone, and welcome to Law Stories. Today, we are going to discuss a very important topic in family law: divorce under Hindu law. In ancient times, divorce was not allowed. Marriage was regarded as a sacrament, a permanent and indissoluble union of husband and wife. According to Manu, a wife could never be released from her husband, not by sale, not by abandonment. This meant that once married, the tie was completely unbreakable. Mutual fidelity till death was considered the highest duty, or dharma, of both husband and wife. The duty of a wife continued even after the death of her husband. She could never have a second husband. Kautilya's Arthashastra did allow dissolution of marriage, but only by mutual consent, and only in the unapproved forms of marriage. Not in the approved, religious forms. Still, Mena's strict view, that marriage was indissoluble, remained more influential. Divorce was not part of the main Hindu texts, but if there was an established custom, it could be recognized. For example, in Bombay, Madras, and Saurashtra, some customs and even legislation permitted divorce. The Bombay High Court struck down a custom where divorce could be obtained just by paying a caste fine. But the Madras High Court upheld a custom that allowed divorce if both spouses consented. Next, during the British period, divorce was introduced for the very first time by law. This was under the Native Converts Marriage Dissolution Act of 1866. The act applied when a Hindu converted to Christianity. If the spouse, husband or wife, deserted or repudiated the convert, then the convert could file a petition in court. The marriage could be dissolved, and both parties were free to marry again, just as if the first marriage had ended in death. Now we come to the present law. The Hindu Marriage Act of 1955 brought a revolutionary change. For the first time, divorce was formally introduced for Hindus. This act reflects modern social, political, and economic changes. The divorce provisions are found in sections 13, 13b, 14, and 15. Section 13 lays down the grounds for divorce. Section 13b provides for divorce by mutual consent. Section 14 says no divorce petition can be filed within 1 year of marriage, except in cases of exceptional hardship or depravity. And Section 15 lays down the rules for remarriage after divorce. In 1976, a major reform came with the Marriage Laws Amendment Act. This act made some very important changes to divorce law. First, adultery. Earlier, a spouse had to prove continuous living in adultery. But after the amendment, even a single act of adultery is enough. Second, cruelty and desertion. Initially, these were only grounds for judicial separation. The amendment upgraded them, making both full grounds for divorce. Third, the waiting period. Earlier, for grounds like venereal disease, the law required a minimum waiting time. The amendment removed this restriction. This meant divorce could now be obtained much faster. Along with these reforms, the Hindu Marriage Act also introduced some more important provisions. Section 13a, Alternative Relief. Here, if a full divorce is not justified, the court may still grant judicial separation. Section 13b, Divorce by Mutual Consent. This was a revolutionary step, allowing both parties to jointly agree to end their marriage. It reduced the purely sacramental nature of Hindu marriage and gave it a modern, contractual aspect. Finally, the time limit for petition. A divorce petition can only be filed after 1 year of marriage, except in cases of exceptional hardship or moral depravity. Now let's understand the grounds of divorce under the Hindu Marriage Act, 1955, available to both husband and wife. Adultery, Section 13, Subsection 1, Clause I. Cruelty, Section 13, Subsection 1, Clause IA. Desertion, Section 13, Subsection 1, Clause IB. Conversion, Section 13, Subsection 1, Clause E. Unsoundness of mind, or mental disorder, Section 13, Subsection 1, Clause E. Leprosy, Section 13, Subsection 1, Clause IV. This ground has now been omitted by the Personal Laws Amendment Act, 2019. Venereal disease in a communicable form, Section 13, Subsection 1, Clause V. Renunciation of the world, Section 13, Subsection 1, Clause V. Presumption of death, Section 13, Subsection 1, Clause V. Non-resumption of cohabitation after a decree of judicial separation, Section 13, Subsection 1a, Clause I. And finally, failure to comply with a decree for restitution of conjugal rights, Section 13, subsection 1a, Clause E. Let's begin with the first ground of divorce under Hindu law, adultery, under Section 13, subsection 1, Clause I. After the Marriage Laws Amendment Act of 1976, adultery became a recognized ground for divorce. Earlier, the law required proof of continuous living in adultery. But now, even a single act of adultery is enough. Adultery means voluntary sexual intercourse of either spouse with any person other than their husband or wife. However, if the intercourse is the result of rape, it is not voluntary, and therefore not adultery. Importantly, it must take place after the marriage. Pre-marriage affairs or unchastity are not valid grounds for divorce. Now, let's look at the conditions and standard of proof for adultery under Hindu law. First, the conditions. The petitioner must not have helped, connived, or condoned the act of adultery. For example, if a husband continues to live with his wife and cohabit with her even after knowing about her adultery, the law treats it as condonation. In such cases, divorce cannot be granted. Section 23, subsection 1, Clause B. Next, the standard of proof. Adultery is by nature a secret act. It is very rare to have direct evidence or eyewitness testimony. Courts usually distrust such direct evidence. Therefore, adultery is mostly proved through circumstantial evidence. This may include proof of non-access combined with the birth of a child, confessions or admissions by the guilty spouse, medical evidence such as blood group tests, or even modern evidence like CCTV footage, letters, or electronic messages. The guiding principle is not proof beyond reasonable doubt, but the preponderance of probabilities. The evidence in adultery cases must be strong enough to make a reasonable person conclude that adultery has actually occurred. Mere suspicion or probability is not enough. A landmark case on this point is Hargovinda Soni vs. Ram Dulari, 1897, Appeal Cases 395. In this case, the husband, Hargovinda Soni, claimed that he had no access to his wife from April 28, 1968, onwards. Yet, the wife gave birth to 3 children after that period. The husband argued that at least one of these children could not be his. To verify, medical evidence was brought before the court, including blood group tests. The results were clear. The third child's blood group was such that the husband could not possibly be the biological father. Based on this evidence, adultery was held to be proved, and divorce was granted. This case shows how courts rely on scientific and circumstantial evidence, not just suspicion, to establish adultery under Hindu law. The court held that, since the husband had no access to his wife, and medical evidence clearly proved that the child could not be his, it was obvious that the wife had an illicit relationship with another man. Therefore, a decree of divorce was granted in favor of the husband. The court also clarified an important principle: in matrimonial cases like adultery, the standard of proof is not the same as in criminal cases. It is not proof beyond reasonable doubt. Instead, adultery can be proved on the basis of the preponderance of probabilities, which is the civil standard of proof. This means that if the circumstances and evidence make adultery more likely than not, the court can accept it as proved. Now let's move to the second ground of divorce under Hindu law, cruelty, under Section 13, subsection 1, Clause IA. Under this section, either husband or wife may seek divorce if the other spouse has treated them with cruelty after the marriage. Originally, before 1976, cruelty was only a ground for judicial separation. But with the Marriage Laws Amendment Act of 1976, it became a direct ground for divorce as well. The act itself does not define what cruelty means. Instead, its meaning has been developed by the courts through important case law, covering both physical cruelty and mental cruelty. In English law, cruelty was defined in the case of Russell v. Russell as a danger to life, limb, or health, or a reasonable apprehension of such danger. However, in Indian law, this strict definition is not followed. Indian courts recognize both physical cruelty and mental cruelty as valid grounds for divorce. Importantly, cruelty must be serious enough that living together becomes impossible. Ordinary disagreements or the usual wear and tear of married life do not amount to cruelty. Types of cruelty can be divided into physical cruelty and mental cruelty. Physical cruelty involves bodily harm or violence. Even 1 or 2 acts of beating may be sufficient. For example, a husband physically abusing his wife, or a wife threatening physical harm. Mental cruelty is more common and has a wider scope. It includes conduct causing mental pain, agony, fear, or even loss of reputation. Mental cruelty can also occur while living separately, for instance through abusive letters or defamatory complaints. Examples of mental cruelty include false accusations of adultery or dowry, continuous abuse, insults, and humiliation, threats of suicide or filing false criminal complaints, neglect, refusal to live together, or studied indifference, malicious allegations that damage the reputation of the spouse. Some important cases illustrate mental and physical cruelty under the Hindu Marriage Act. In Dr. N.C. Dastane v. Mrs. Dastane, A. 1975 SC 1534, the wife threatened to commit suicide, insulted the husband's father, locked out the husband, and ill-treated the children. The court held that these acts amounted to cruelty. In Rajendra Bhardwaj v. Anita, A. 1993 Del. 135, the wife refused to consummate the marriage, abused her in-laws, and threatened to file a false dowry case. The court held these actions to be cruelty. Some key principles have been established regarding cruelty under the Hindu Marriage Act. Mens rea is not required. Cruelty can be unintentional. Each case is decided based on its own facts, considering background, culture, and social conditions. Courts focus on the cumulative effect of acts, not isolated incidents. Mere suspicion, small quarrels, or trivial incidents do not amount to cruelty. Relief is granted not to punish the spouse for past acts, but to protect the future matrimonial life of the aggrieved party. Examples of acts that courts have considered as cruelty under the Hindu Marriage Act include threatening suicide or filing false dowry complaints, defaming the spouse in public or with authorities, refusing cohabitation or sexual relations for a long period, physical assaults or bodily harm, forcing immoral acts, such as prostitution or sharing a bed with strangers, neglecting a seriously ill spouse, harassing the spouse with repeated false complaints, performing an abortion against the husband's wishes, living with another partner under the same roof. Desertion occurs when one spouse abandons the other without reasonable cause, against the deserted spouse's wish, for at least 2 continuous years immediately before filing a divorce petition. The essential elements that the petitioner must prove are factum of separation, meaning the spouses are living apart. Previous cohabitation is necessary. Animus dicerendi, which is the intention of the deserting spouse to bring cohabitation permanently to an end. Desertion under Section 13(1) IB occurs when one spouse abandons the other without reasonable cause, against the deserted spouse's wish, for at least 2 continuous years immediately before filing a divorce petition. The essential elements that the petitioner must prove are factum of separation, the spouses are living apart. Previous cohabitation is necessary. Animus dicerendi, the intention of the deserting spouse to bring cohabitation permanently to an end. No consent, no reasonable cause, the separation was against the petitioner's wish and without good reason. Continuity for 2 years, both fact and animus must have continued during the statutory 2-year period. No own wrong, the petitioner must not have provoked or caused the separation. Desertion is a continuing course of conduct, not a one-time act. It can be actual desertion or constructive desertion. In constructive desertion, the conduct of one spouse forces the other to live separately. A temporary absence with the intention to return does not amount to desertion. The deserting spouse must have a permanent intention to end cohabitation. In actual desertion, the petitioner must prove separation from the other spouse. Animus dicerendi, intention to bring cohabitation permanently to an end. Absence of consent and no reasonable cause for separation. Continuation of both fact and animus for at least 2 continuous years. If the deserting spouse later makes a bona fide offer to return, desertion comes to an end. Constructive desertion occurs when one spouse's behavior makes home life impossible and forces the other to leave. In such cases, the wrongdoer is treated as the deserter. For example, if a husband's cruelty forces the wife to leave, the husband is guilty of desertion. If the spouses separate by mutual agreement, it does not amount to desertion. Separation due to mental or physical incapacity, or any genuine reason, may be considered a reasonable cause. The deserted spouse must generally show readiness and willingness to resume married life. Conversion occurs when one spouse ceases to be a Hindu by converting to another religion. In such a case, the other spouse may file for divorce. Conversion does not automatically end a Hindu marriage, but it is a recognized ground for divorce and for judicial separation under Section 10, after the amendment. The petitioner must prove that the other party actually ceased to be a Hindu through a valid conversion, for example, to Islam or Christianity. Conversion provides civil grounds for relief, but the marriage obligations do not dissolve automatically upon apostasy. A spouse may seek divorce if the other is incurably of unsound mind, or suffers from a mental disorder, whether continuous or intermittent, to such an extent that the petitioner cannot reasonably be expected to live with them. The term, mental disorder, includes mental illness, arrested or incomplete development of the mind, psychopathic disorder, schizophrenia, or any other mental disability. Psychopathic disorder refers to a persistent disorder or disability of mind that results in abnormally aggressive or seriously irresponsible conduct, whether or not it is treatable. The degree of mental disorder matters. Not all mental abnormalities qualify for divorce. The disorder must be so serious that living together becomes unreasonable. Courts assess both the degree and impact of the disorder, not just the diagnostic label. If the respondent refuses to undergo a medical examination, the court may draw an adverse inference against them. In the case of Ram Narain Gupta vs. Rameshwari Gupta, decided by the Supreme Court in 1988, the court explained that a mere diagnosis is not enough. The severity and effects of the disorder must justify the granting of a divorce. Leprosy, which was previously a ground for divorce, has been removed by the Personal Laws Amendment Act of 2019. Earlier, only virulent and incurable forms of leprosy could justify divorce, but it is no longer recognized as a ground. Venereal disease is still a ground for divorce. If a spouse suffers from a communicable venereal disease, the other spouse may file for divorce. The petitioner must prove that the disease is communicable. It is not necessary to show that the disease was not contracted from the petitioner, but under Section 23(1), relief may be denied if the petitioner's own conduct caused the disease. If a spouse renounces the world by becoming a sannyasi or entering a religious order, the other spouse may file for divorce. It is important to note that mere declaration of renunciation or simply wearing the clothes of a sannyasi is not enough. Proper ceremonies and genuine renunciation are required. Renunciation is treated as civil death, which allows the marriage to be legally dissolved. Next, presumed death. If one spouse has not been heard of as being alive for 7 years or more by those who would naturally have heard of them if alive, the other spouse may file for divorce. After the decree is granted, the aggrieved party is free to remarry, and children from the second marriage are considered legitimate. If a second marriage is solemnized without a decree but on the reasonable belief that the first spouse is dead, only the missing spouse may challenge it, and the law protects the second marriage in limited ways. Next, if a decree of judicial separation has been passed and the other spouse does not resume cohabitation for 1 year or more after that decree, either party may file a petition for divorce. Cohabitation means more than just living together. It requires acting as husband and wife, the husband supporting the wife, and the wife performing her marital duties. Sexual intercourse is strong evidence of cohabitation, but it is not necessary. The petitioner must prove that marital status and behavior as husband and wife have not resumed for at least 1 year following the judicial separation decree. If a decree for restitution of conjugal rights has been passed and the spouse fails to comply with it for 1 year or more, the other spouse may file for divorce. The aggrieved spouse does not need to show extra efforts to make the other comply. Non-compliance for 1 year is sufficient. However, compliance may be excused if the non-complying spouse had a valid reason. For example, if the wife lived with her husband briefly in good faith after the decree but left again due to ill treatment, her non-compliance may be justified. Thank you.